This lecture is entitled Bottom of the Ninth. What I want to do in this lecture is talk about the Ninth Amendment to the Constitution, the last substantive rights-based amendment in what we call collectively the Bill of Rights. The Ninth Amendment, in the words of the eminent historian Jack Rakove, is a joker that's never been played. It's a card that's never been played in a hand of constitutional law in any meaningful way in American constitutional history, though some justices have used the amendment to justify their opinion. It has never been the basis of a majority, therefore a binding precedent of American constitutional law. But it's nevertheless a fascinating amendment. So there's an interesting question of why it's never been used, and I think we might get an answer to this at the end. But there's also an interesting question about how the amendment works. The amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Let's take a second and break that down. The enumeration in the Constitution of certain rights, which is the word enumeration means. It means to make a list. So we can imagine that the Constitution, and we could look at it and see that the Constitution lists certain rights that we have. It then goes on to say, but the enumeration of those rights shall not be construed or understood or used to deny or disparage others retained by the people. And there really should be another word in there, other rights retained by the people, because that's what that implies. So the Ninth Amendment says, potentially, and scholars disagree with this, jurists disagree, it's not overwhelming, but there is some debate about this, of whether or not in other words, whether the Ninth Amendment says that whatever rights are listed in the Constitution and other places are not exhaustive of the rights that the Constitution gives us. In other words, are not exhaustive of the rights that we can hold up against governments, both national and state. In other words, there are more rights that we have that are just as important as the rights that are written down or enumerated. Right? There are other rights that we have. Well, this is potentially problematic for the way that we understand American constitutionalism. We understand it as a higher law, as I've said many times, that they are the rules of the game under which normal kinds of political operations happen. Right? They're the rules of the game. We wrote the Constitution down to both empower the national government and to limit it at the exact same time. And by writing things down, we limit. Writing is an inherently limiting endeavor at the same time that it can also create things. Right? We like to think that God created the world through writing, right? In Genesis, right? He wrote the world. Well, we wrote a constitution. But the question is that constitution exhaustive of all of the rights? And the Ninth Amendment seems to suggest that it's not. And that's potentially problematic for our notion of a higher law constitution. Because the idea with the higher law constitution, as we've heard especially with the amendment lecture, was that it'd be very difficult to change. Not impossible, but very difficult to change. Certainly ordinary pieces of legislation do not equal that higher law. But if the Ninth Amendment says that there are other rights retained by the people, besides those that are enumerated or listed in the Constitution, then by ordinary simple legislation or simply an assertion by a single justice that there is another right out there that we might have that's just as important, that's just as much a part of the rules of the game as those rights that are written down, that potentially violates Article 5 of the Constitution. It potentially puts into the Constitution, without going through by skipping the amendment process, an amendment to the Constitution that has not gone through the proper channels. But one other way to understand the Ninth Amendment without criticizing it, in a sense, without looking at it negatively, would be to use the idea that the eminent political and legal philosopher Ronald Dworkin's argument. And he makes an argument that we should understand constitutional rules of the game, right? These higher law rules, through a simple exercise of making a distinction between concepts and conceptions. What he means by that, for example, would be we can have a conception of what due process of the law is. Right? Or we can have the concept of due process of law, this big, airy concept. But then at particular periods of time, we can have particular conceptions of what that means, to whom it applies, how it works. Right? So there'd be a difference between the concept of due process and individualized or even periods, right, of conceptions of what that category of rights means. Now, if we understand constitutional law or higher law in that way, the Ninth Amendment seems to make a lot of sense. That yes, there are other rights out there that we don't list down for a lot of reasons. If we do buy into this argument that these concepts, that these are the concepts, then it would be impossible to list in a constitution all of the rights that we have. We would have to discover new ones or resurrect new ones or get rid of some too, if the case may be. So in that sense, the Ninth Amendment makes a lot of sense. That there are, of course, other rights that we have. The rights that we've enumerated here are very important ones, but they're not exhaustive of the rights that we have. Now, lest we think that this is unimportant because it's, in the words of Jack Rakove, a joker that's never been played, the Ninth Amendment is very important in the overall development of constitutional law. The first time that it becomes important in our generation, in the last 40 years, is in a very seminal case called Griswold versus Connecticut, where the court recognizes a right to privacy, a general right to privacy, but within that right, or under that concept of privacy, is the right of marital privacy, specifically whether or not husbands and wives can choose whether or not to use contraception. Now, there is no specific enumerated right to privacy in the Constitution. You can look through your pocket copies all day and all night. You will not find the word or the term right to privacy. The first justice, and the court said that there was one, though. The first justice who ruled on this, Justice Douglas, said, I can find a right to privacy. I can look at the enumerated rights, specifically the Bill of Rights, and they form, he said, penumbras and emanations. In other words, the Third Amendment says we're going to prohibit the quartering of soldiers in your home. Well, even though that doesn't specifically say privacy, that sends up almost a smoke signal-like idea of privacy. Why would you be concerned about prohibiting soldiers from their home, from your home, if you weren't first very concerned about privacy? Similarly, with the Fourth Amendment's prohibition against unreasonable searches and seizures, and the requirement that warrants be very specific when they're issued. Why would the founders have been concerned to write down that right, enumerate it, make it a fundamental right, if they weren't also very concerned about privacy? But Douglas wasn't the only one who wrote a concurring opinion agreeing that there was this right to privacy. Another justice, Justice Arthur Goldberg, said that this right to privacy could be found in the Ninth Amendment. He said this marital right to privacy can be found in the Ninth Amendment. Now, of course, the Ninth Amendment doesn't say that. Nevertheless, we have, from Griswold versus Connecticut, recognized the marital right of privacy. Just a few years later after that, we recognized a single person's right to privacy with contraception. And just 8 years after the 1965 case of Griswold versus Connecticut and Roe versus Wade, we recognized that that right to privacy was also much larger. It was large enough to encompass a woman's right to choose whether or not to have an abortion. And that right was a private right between her and her doctor. So at the very least, even though the Ninth Amendment has not been used in any major controlling case, or in other words, we haven't had a majority of the court, just that majority use the Ninth to construe extra rights. We have had some. Nevertheless, the Ninth Amendment has become extremely important in the notion, in the area of rights in the United States. One last thing about the Ninth Amendment, it is the court that's interpreting what these rights are. If they were to use the Ninth Amendment, they would have to decide what those other rights are besides those that are written down. And in that case, Griswold versus Connecticut, there were two dissents. Justice Harlan and Justice Hugo Black. And I would encourage you to read Justice Hugo Black's dissent, not so much because I agree with it, but because I think it's a brilliant refutation of the use of the Ninth Amendment and this other argument that was used in the case to find a right to privacy, but more generally, a wonderful refutation of the argument against adding things to the Constitution outside of the amendment process. Now, if Black's right, then we have to understand the Ninth Amendment in a very limited way, in a very limiting way. But if the Ninth Amendment is understood in the way that, say, Ronald Dworkin understands it, that these are general concepts, and at various points of time we can have different conceptions of what that concept means, then the Ninth Amendment is a very, potentially very, very powerful rights-creating amendment. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.